Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution, its honorable court.
Hi, welcome to the First Court of Appeals. I'm Justice Goodman. I'm here with Justice Landau and Justice Countess. And we're here to listen to oral arguments in the case of 01-20-00434 CR, styled Wade Harold Thompson versus the state of Texas. And I understand from the bailiff that the appellant would like to reserve 5 minutes for rebuttal. I'd ask the attorneys for the parties to introduce themselves at this time.
Yes, sir. For Mr. Thompson, my name is Jake Spiegelhauer.
State Andrea Bender, the appellee, District Attorney, Grimes County, Texas.
Mr. Spiegelhauer, I'll turn it over to you.
Thank you very much. And if it pleases the court, on January 26, 2015, we have a situation where following a traffic stop for a defective third brake light, the deputy in this case develops a suspicion of some wrongdoing by Mr. Thompson and the passenger in the vehicle, thinking that there's some wrongdoing. He is detained at that point, pulled out of the vehicle, cuffed, and then the deputy proceeds to search the vehicle, including a duffel bag, where he finds a spare cell phone. You will notice from the evidence and from the videos of the deputy's body cam that the cell phone is clearly off at the time that he pulls it out of the duffel bag. However, minutes later, we are led to believe that inadvertently, the deputy then turns the phone on and causes the screen to illuminate, at which time he's able to confront the defendant, Mr. Thompson, and what he declares is a perceived lie that the phone doesn't work. Following that, he then gets permission and consent to turn the phone on for the express purpose and limited purpose of trying to make a phone call. He pulls up the call screen, tries to make a phone call, realizes it doesn't have service, and then again, supposedly when he is trying to return it to the home screen, he again inadvertently goes into the photo section of the phone beyond the express consent and discovers what he views as child pornography. The state and yes, ma'am.
Mr. Spiegelhauer, may I ask, what, in your opinion, is the scope of consent here? And does it include the sort of getting to the place that he has consent to get and sort of backing out of the place he had consent to be in? Yes,
ma'am. Clearly, and the judge ruled in this case that the consent was limited to making a phone call. And in this case, Mr. Thompson himself actually led the officer into the area where he could make the phone call from the home screen to the call screen. Now, it's been argued that by the state that he would then have consent to return it to that home screen. We don't necessarily disagree with that. But once he returns to the home screen, we believe the consent at that point has ended. Now, the deputy testified and the state contends that he went directly from the call screen to where he found the photos. The problem with that is the evidence just doesn't support that. Multiple experts in the case testified to the fact that from the call screen, he would not have been able to hit the icon that he claimed to have hit to get to the photos. Rather, he would have had to hit the little house button that returns him to the home screen. But once he did that, I believe the argument essentially, ends at that point because he's accomplished his purpose. He's gone to the limits of the scope of consent that he's been provided. To then continue to hit any other button, including the icon that he said that he hit, at the very least shows reckless disregard for the privacy interests that the appellant had in his phone. Especially in this case with a situation where he says that he was not familiar with these type of phones or what the various buttons on them did. So once he's returned it to that home screen, without asking for further direction or getting further consent beyond that point, he can't go any further. And nothing at that point was in plain view, which is what the judge found, is that there was no search because it was in plain view once he inadvertently hit that that icon on the home screen.
Let me ask a follow-up question. So you say you don't contest that there was consent to return it back to the home screen. At that point, that is within the scope to return it to the state that the officer took it in. So if there's a mistake, if we believe, as the trial court did, that the photos were opened inadvertently, who is that mistake charged to? In that, what I'm asking is it within the scope of consent that there may be a mistake, or do you not get to make any mistakes when you're operating in an unfamiliar phone environment?
Sure. To return it back to the home screen, to answer your initial question, there was not at least an express consent to go from the actual call screen back to the home screen. Now, I do believe that probably that would be reasonable to return it to the state that he found it in initially. As far as whether there was a mistake, the mistake happens after it's been returned to that home screen. So the mistake would have to be charged in that case to the deputy for continuing to go press buttons on the phone that go beyond where he's already returned the phone to. Once he's at the home screen, there's no sense in hitting any other buttons. And whether he inadvertently hit one that took him into a gallery section, it's just not reasonable at that point to continue functioning on the phone. I would also like to point out, at least following the trial, following the sentencing, new evidence, I guess, was turned over, and we've argued, that we were entitled to a motion for new trial, and the judge heard evidence on that the same deputy, after this case had started and after he'd been appointed to the district attorney's office, he illegally used, or against policy, used a law enforcement database for purposes not of law enforcement, to look up private persons, information and use that for personal reasons rather than law enforcement purposes. It is our contention that based on that, we were entitled to a new trial based on the new evidence, as it would have shown in this case similarities to what we had argued.
Mr. Stiegelhauer, sorry to interrupt, but
Yes,
I have a question specifically about that. How closely related does Officer Payne's misconduct, for lack of a better word, need to be to the cell phone activity that is at issue here, in order for it to have been wrong for the trial court to not give you a new trial?
Sure, and I think courts have routinely said that you don't have to have a one-to-one comparison, so they don't have to match exact facts. In this situation, we argued, and Investigator Payne, claimed that this was an accident. We argued that he went beyond the consent that was provided him. I think at least in this situation, we have similarities, that we have him showing his ability to use a computer. We have a computer and a cell phone. He claimed a certain level of not being tech savvy by not knowing what the functioning of the phone was. Given that we have a similar situation where he's looking up computer images or computer information, it kind of could rebut that defense that he provided. Additionally, we have a situation where he has consent to use this law enforcement database for one purpose, but goes beyond that consent, similar to what we were arguing at the trial level. In situations where essentially we were rebutting what would be their defensive theory, I don't think we're charged with having to, have the facts align perfectly. But I think we have enough here that does align that would provide reason for the jury, if they heard this evidence, to compare those two things similarly and possibly find for us in the trial setting.
Procedurally, is that, oh, I'm sorry, well, let me try to make this quick. Maybe
Go ahead.
Procedurally, is that how, so if we were to agree with you on, would this go back for a new trial post with the evidence still suppressed, but with an ability for the jury to consider this? Is that what does that
What
make
would be
sense?
the remedy is what we're asking.
Sure. The evidence was never suppressed, so I'm not sure that all the
I'm sorry,
evidence.
I'm sorry, I said it the wrong way. I'm sorry. I mean, in other words, is this to be considered, is this only to be considered in a new trial, a new jury trial, and then the trial court's ruling on the motion to suppress stays the same? I mean, doesn't it impact potentially both?
Yes, ma'am. I think it would be fair game for both, because we would have been able to bring it up at the motion to suppress had we known about it at the time. This happened years after the actual motion to suppress was argued, though.
I also have a question related to remedy. I know we're out of time, but we'll be careful
We'll add
to,
some time to the.
we'll
the
give the
state time.
state the equivalent time, I'm sure. In terms of remedy, you all in your briefing talked about 404B, but not really 403, which would have been part of the trial court's analysis had they gotten there. Do we resolve the 403 issue here, or is the remedy to remand that for the trial court to do in the first instance?
I think it would be to remand it to the trial court. They would have to have the first crack at it. The judge didn't make any rulings regarding the purposes that we argue that it should come in on. So I think the trial court would have to have the first option to exclude it that way if he or she so decided.
And I just have one more question about 404B. What is the best case other than Chu for applying 404B to a non-party witness?
By non-party witness, I'm not sure.
I mean, someone who is not a defendant in a criminal case or a plaintiff in a civil case, someone who is like the officer, not a party in this case. I mean, technically he's an employee of the state, but he is not the DA and he's not Mr. Thompson.
Yes, ma'am. And from the defense side, obviously we see it more of the defendants getting into the evidence coming in. So there's not as much case law on that subject. So I apologize. I don't have another case outside of the ones that I cited to give you right now.
If you would be so kind to, after we conclude this argument, to see if you can find something, because that is something we would like to know more about.
Yes, ma'am.
Thank you, Mr. Spiegelhauer, and we'll ask the clerk to add 4 minutes to the time for the state. And with that, I'd like to turn it over to Ms. Bender, and please proceed.
Can everyone hear me?
Yes.
Yes.
Good afternoon. In this particular case, unlike Spiegelhauer's, is that Mr. Payne had a broader consent than Mr. Spiegelhauer is arguing. If you look back at the Reporter's Record, Volume 4, in regards to Mr. Payne's testimony, as well as the video, the body cam video that was trial exhibit 15 or 16, and in the motion to suppress hearing, I believe that is exhibit 15. Is a broader consent to the phone. In fact, what the defendant tells him to do is he tries to give the code for Mr. Payne himself. Mr. Payne then retrieves the phone, and the defendant shows him how, and you can see this on video, shows him how to actually open the phone. In that conversation, the defendant if you look at the record of Mr. Payne's testimony as well as the video, tries to show Investigator Payne how to get to a pull down menu within the phone. It was proved to him that it had no service. Then, out of frustration, the record would show that the defendant told him to make a call Rodney. And so, in looking at the scope of someone's consent, the court looks at what an objectively reasonable person who is involved in that conversation would believe. And so it's the state's position that a reasonable person would believe, based on the consent and the conversation, that Investigator Payne had the ability to open the phone. He actually would have had permission to go further into the phone to reach this pull down menu, which he was unsuccessful in doing because he said that he was completely unfamiliar with this type of phone. And I would point to the court that Flowers v. State 438 Southwest 3rd 96 addresses a very similar issue to this. And it talks about how that the scope of the search is also dictated by the familiarity of the person conducting the search of the phone.
Ms. Bender, I would like to ask you the same question I asked Mr. Spiegelhauer. To the extent that the officer had permission to get into the phone and then kind of return it to the home screen, that there's error by the officer after that, which caused the inadvertent display of the photos, to whom is that error charged? Because, I mean, under his argument, the consent ended once the officer reached the home screen.
And the officer's testimony, and again, I would disagree with Mr. Spiegelhauer's representation or the evidence would show, I believe, but both experts as well as Investigator Payne, is that he hit the round circular button that is at the very beginning of getting onto this phone. And so then when he hit that, that is when, because of the damage to the phone and basically the poor quality of the phone is what the expert said, that it was possible that, in fact, both experts did that, to pull up those images. So our argument is that when he presses that home button, he is the button to open the phone and a button to close the phone. So we would say that the mistake would be inadvertent and would fall in just in so many of the other cases of plain view. At that point, he is legally at a position of consent to be in that phone at that point. And then those photographs are then in plain view. And at that moment, and the testimony was very clear, he then immediately contacted a supervisor, pulled the battery out of the phone, and sought a search warrant.
With that in mind, Ms. Bender, doesn't that make the later discovered information or evidence about officer, how does that not change the way that the defense might have been able to put on their case in light of the later evidence about the officer's misuse of a government database?
And I would point out to the court that I've cited multiple instances of cases where that information would not be admissible evidence. And in fact, the court did rule in the motion for a new trial, the court ruled that this evidence would be inadmissible and not material. And it wouldn't be for several reasons. First off, generally, and any kind of extrinsic conduct is not admissible to attack the credibility of a witness. That's normally only done, you can do it through reputation witnesses. You can do that.
What about 404B though? Let's move ahead a little bit.
and I'm glad you brought that up, because believe I just discussed that in my brief. But under 404B, evidences of other acts would be admissible to prove such as motive, intent, scheme, or other relevant purpose, but not to act in conformity with bad character.
Right, but in your brief, you kind of skipped over the part that I think is the most relevant here. So I'd love it if you could address that, which is the absence of mistake, the lack of accident, which I think is at issue here.
And what I would say to that is what the defense is really actually do that his a database is not, that is a private database that occurred many years after this particular incident, is not relevant, nor is it admissible even under 404B. Because what they're really trying to use it for is not to say that to prove intent or anything like that. What they're really trying to do to say is he accessed this TLO database in reference to a divorce matter that's a completely personal matter, and that shows a propensity here to do the act of an illegal search, and that is conformity evidence. That does not.
Well, I understand you're saying that, but let's assume it's not conformity and that it is being requested to show a lack of mistake.
Well, we would argue that it would not be admissible for that matter either, because the defense argued that this was a intentional act. And our argument is that this is consent within the scope of consent. So we do not believe that we would be applicable at all in this particular case.
Okay, let me come at it from a different angle. Did the state open the door in this case by claiming it was an accident and that Payne did nothing wrong by accessing photos that the defendant did not specifically consent to have accessed?
I would give you an example of a couple cases that I cited in my brief. For example, in Valdez v. State, an officer, a defendant tried to use a disciplinary suspension for violating a variety of rules, for concealing that fact from his superiors, and the defendant tried to use those specific instances of conduct to attack his credibility and to attack his actions. And the court found that would not be specific instances of conduct should not be allowed to use to attack someone's credibility, because that's essentially what we're talking about here is credibility.
But what about the lack of mistake? What if it's not about credibility?
I don't see how his accessing a TLO database is remotely the same as a illegal search.
He's not allowed to access that database for personal reasons, is he?
Not supposed to access it for personal reasons. That is correct.
So do you consider that to be a bad act, coming under the heading of crimes, wrongs, or other acts?
Do I consider that a prior bad act that would be admissible? No, I do not. I believe that that's irrelevant, and the court agreed with that. In fact, the court, if you notice in the record, said, how is someone's love life or an action taken in someone's love life relevant to this case? And I don't think that it is relevant at all. And in fact, the record also establishes that what he accessed are mainly public records. That database compiles those public records together. But for example, it was a vehicle search. Is one of the things, a vehicle search is that was community property. So that is not a prior bad act. One of that was property that they owned, a VIN number on a vehicle. That is not a prior bad act. That is gaining access to public information that he could have found in another source. So no, I don't agree that that is a prior bad act. And he also, that on one of those searches is a comprehensive search about his wife. he already has access to that information. So that is not a prior bad act. So I
If
do
it was
not,
not a prior bad act, why was he dismissed from his position?
he had numerous performance difficulties in the months coming up to that particular incident. And that access was a culmination and the last straw for our office. But he was not solely asked to resign based solely on that. There were other factors based on just not performing his job as he was supposed to do. Meant timeliness of getting things done in reference to trial, communicating with lawyers in this office about cases that like he was supposed to. So that is not the sole reason for his resignation.
Ms. Bender, let me ask you if I'm understanding your argument in your brief correctly. Are you saying that the only way to get this evidence in of a prior act is if it shows personal animus against the defendant?
I'm saying under my response was to the defense's argument that this was admissible under 405B.
Okay.
And under the 405 provision, I believe the only way that would be admissible is to show animus or bias. And I apologize if wasn't very clear about that in my brief, but that was in response to the defense's argument under 405.
Okay, when a person's character or character trait is an essential element of a charge, claim, or defense, the character or trait may also be proved by relevant specific instances of the person's conduct.
Because that was the argument that was made in the motion for new trial as well, and one of the arguments that he made in his brief. I was responding to that.
Okay, I understand better. Thank you.
And in my brief, I presented a couple other cases in regards to whether this evidence would be admissible. And in response to Justice Countess' statement about temporal, asked about how close in time. I would point out to the court that this offense occurred all the way back in, I believe, 2015. Or early part of 2016. So the time period where he would have been illegally searching, if you agree with the defense's position, is not close in time to the accessing of the TLO. And in Gamez, for example, the Dallas court there looked at a forensic testing witness's testimony, and they wanted to cross-examine her on a labeling error at the forensic lab that occurred 4 years prior to her testimony. And the court said that temporal proximity made that, first they said it wasn't proper impeachment evidence, but also they said it had little or any probative value in respect to the appellant's case. So I hope that might answer one of your questions, Justice Countess, in that regard.
That was part of it. I also just was sort of trying to probe on the actual specifics. I mean, for example, and I don't like to do hypotheticals, but I'm going to do one. I mean, if this was not about, if the activity he was engaging in, using his, access to government databases involved other people he had arrested, or even something somewhat, more specifically related to this case, does that change things? Is that at least that far along? How do you see that?
I think that,
I'm trying to get the scope here.
and I think that, yeah, if it was more similar and it was involved in his duties, perhaps. But there, as I said, there's several cases out there that I cite in my brief, Valdez, where they tried to use a report of prior misconduct by an officer as impeachment using a specific conduct, and the court said no. That you can't do that. In Dalbasco v. State, there were allegations that that particular officer had been dismissed from the force. That is 978 Southwest 2nd 236 for lying. And the court said that that would not be admissible and would not trigger a motion for new trial because the specific instances of misconduct were not admissible. So I would point you to a couple of those cases. I think that could give you, some clarity on the information, but specific instances of a witness are simply not admissible under the rules of evidence unless they meet a very small exceptions.
And I think that's where I think that maybe I shouldn't say we, that's where I'm trying to get a good understanding of the boundaries, because I do think to me, what I see as possible is this information goes to the defense's actual, theory that it wasn't necessarily an accident when he stumbled on those photos. And so couldn't that information about him also snooping in government computers show that, is there not a way that would have helped show that it wasn't, he's done something similar, not for,
I would argue
the purposes of showing not that it wasn't accidental. Is that not an area that this could go to?
Essentially, what you're saying there is propensity evidence. That is just the same that saying that he lied in this particular instance, so that he's always a liar. And so I don't believe that it would be admissible evidence, because what it's really being used for is not to show that it was a lack of mistake, but it's to show that if he did this act by accessing the TLO, then he did it improperly here. And that is propensity evidence. That is conformity with conduct. And that is what the rules of evidence specifically say you cannot do. That would be our position.
Thank you.
And in regards to the motion for new trial, I would just point out to the court that the court did hold a hearing and ruled that this evidence would be inadmissible and not relevant and merely impeaching and would not be. I thank you for your time this afternoon.
Thank you.
Thank you, Ms. Bender. I'll turn the court back to Mr. Spiegelhauer for his rebuttal.
Thank you. I'd like to point out on the motion for new trial, the argument that it appears to be made by the state is that this evidence is not permissible merely for the purpose of impeachment. And that is not something that we disagree with. The cases that have been cited to you regarding disciplinary reports not being admitted, all of those were being admitted for the purpose of impeaching the witness and the credibility of the witness, not for some other purpose, which, if there is another purpose, specific instances can absolutely come in. And we don't have to fit it into some narrow box to make it. The courts have argued that 404B is a rule of inclusion, not one of exclusion. I think in this case we have, as y'all have all pointed out, the state arguing that the officer, Deputy Payne, accidentally stumbled upon that. That gives us grounds to attack that and to provide evidence that shows similarities in another situation where it might not have been an accident. So contrary to these other cases, there was no conduct by the officers in those other cases that were cited suggesting that there was any bad behavior on the part of the officers. It was just merely attacking their credibility for truthfulness or things like that, which is not solely what we're trying to do. Obviously, credibility gets attacked at any point you offer evidence of prior bad acts. But if you can fit it into another category, 404B and we believe 405B says it can come in. And that was the purposes that we sought to have it admitted. And we don't believe the court made any ruling on that. The only ruling that it made was that it wouldn't show motive to lie, which again was not what we admitted it for that purpose. I'd also like to point out, as far as the characterization of the evidence, I would urge you, all of you, to watch the videos that were associated with this case, most specifically the in-car videos. Because contrary to what Ms. Bender argued, the deputy did not simply open the phone and immediately hit that circular icon. He clearly went and tried to make a call. And we've now been through a motion to suppress, a trial, a brief's been written, and oral arguments, and the state has yet to address how they got from the call screen back to the home screen. But yet both experts pointed out that the only way to get from the call screen back to the home screen would be to hit that house. So contrary to what has been argued this entire time, it simply could not have, excuse me, could not have happened the way the deputy said. And I think by not addressing that point and not addressing how you get from the call screen back to the home screen seems to have a tacit admission by the state that if he did anything more besides hit that circular icon, then that evidence must have been illegally obtained. And the experts in this case clearly showed that to get to the pictures in Exhibit 3, there had to be more steps taken other than what the deputy claimed to have happened. So the fact that the state has yet to address that, their own experts said that even if the deputy in this case were to have fat fingered the icon he claimed to have hit, he still would have had to hit select one of the albums to get to the pictures in Defense Exhibit 3, which were on the body cam. So if they're not willing to address that, and if they're want to stick with the pressing one time of the phone, if all of you were to find that couldn't happen that way, I think that that's an admission on the part of the state that the motion should have been suppressed if anything more was done.
Mr. Spiegelhauer, what do you make of the crack in the phone leading to this situation?
Clearly, there was a crack on the phone. So, and judging from both experts, they say that can affect when you touch the screen. It can affect how it functions. And both of them were able to show that once you get back to that home screen, you can hit the icon that the deputy said he hits, and it would take you to the albums of the photos. However, both of them also agreed that to go to that next step and to the photos that were actually shown in Defense Exhibit 3 and on the body cam, something else had to have been done.
Thank you, Mr. Spiegelhauer.
Thank you.
We thank you and Ms. Bender for your arguments. The case of Wade Harold Thompson versus the state of Texas has now been submitted to the First Court of Appeals.